I'd like to welcome everybody back. This is the beginning of the first panel, Historic Perspectives on the 19th Amendment, Looking Back, Looking Forward. And we have our student moderator who will be taking it from here, Angela Betcher. So Angela.
Good morning, everyone. Welcome to the first panel of the day. Like Professor Malvo said, this is Historical Perspectives on the 19th Amendment, Looking Back, Looking Forward. We're excited today to welcome 4 esteemed professors to speak as part of this panel. But first, a quick reminder that after our panelists speak, we'll be taking questions from our Zoom attendees. If you have a question, please send it in to us using the Q&A function on Zoom. I'm going to take a moment now to introduce all of the speakers on this panel. The first of our 4 speakers is Susan Schulten. Professor Susan Schulten teaches history at the University of Denver, where she's taught since 1996. She's published several books with the University of Chicago Press, including Mapping the Nation, History and Cartography in 19th Century America, The Geological Imagination in America, 1880 to 1950, and most recently, A History of America in 100 Maps. Professor Schulten's research has been funded by the John Simon Guggenheim Foundation and the National Endowment for the Humanities. She's also the 2013 recipient of the Pacific Coast branch of the American Historical Association's Mapping the Nation Norris Hunley Prize. Next today, we'll hear from Professor Carolyn Ramsey. Professor Carolyn Ramsey is a professor of law here at the University of Colorado Law School, where she has received a Jules Milstein Faculty Scholarship Award and a University of Colorado Graduate Committee on the Arts and Humanities Research Grant. She received a master's in history from Stanford University and a JD with distinction from Stanford Law School. Professor Ramsey has garnered a national reputation for bringing archival history research to bear on issues of violence, punishment, and discretion in criminal law and procedure. And her upcoming book traces the history of legal responses to intimate partner violence from the 19th century through the passage of the Violence Against Women Act. Third, we'll hear from Professor Julie Suk. Professor Julie Suk is the Dean for Master's Program at the City University of New York, the Graduate Center, where she's also a professor of sociology, political science, and liberal studies. Prior to joining CUNY, Professor Suk was a law professor at Cardozo Law School and had visiting professorships at Harvard, Columbia, the University of Chicago, and UCLA Law Schools. Her book, We the Women, the Unstoppable Mothers of the Equal Rights Amendment, will be published in June 2020. Professor Suk focuses on comparative law and society with a particular focus on equality and non-discrimination. She's also a frequent media commentator regarding the recent push to revive the Equal Rights Amendment. Finally, today we'll hear from Professor Mary Ziegler. Professor Mary Ziegler is the Stearns Weaver Miller Professor at the Florida State University College of Law. She has a national reputation of being the premier historian of abortion in the post-Roe era, and her most recent book, Abortion and the Law in America, Roe v. Wade to the Present, was published earlier this year by the Cambridge University Press. Professor Ziegler won the 2014 Harvard University Press Thomas J. Wilson Memorial Prize for best first manuscript for her book After Roe, The Lost History of the Abortion Debate, and is a frequent media commentator on abortion rights in America. Without further ado, I'd like to hand things over to Professor Susan Schulten, our first speaker.
Thank you, Angela. I hope you can all hear me okay. Greetings from snowy Colorado. I'm so glad that you've all tuned in. I want to echo the gratitude I feel for the organizers. I think it's an act of bravery and faith to do the heavy lifting that they all did to pivot to an online webinar. Suzette Malvo and Carolyn Ramsey so graciously invited me sort of late to join this, and I'm really excited to stretch my work in new directions. I want to give a special note of thanks to Teresa Coberly and John Sibre. Teresa, who always does such great work at the law school and with whom I've worked before. And my new hero, Melissa Schentner, who did all the really, really invisible work to make this happen. I was so really impressed and moved by Professor Siegel's words in the opening. They could not have been more helpful in terms of contextualizing what I want to share with you today. I'm going to show you something more interesting than my face, so here we go. There are some images that I think can do a lot of interesting work for us here. I'm going to give you the full screen. And here we go. I'm going to start by presenting a little bit of a puzzle for you. And I apologize if the right end of the quotes have been cut off, but this is a complete and utter reversal by Teddy Roosevelt, one of the most influential politicians in America after his presidency. When speaking to the anti-suffragist Mary Ella Lyon Swift in the early spring of 1911, full stop, he proclaimed that women didn't need the suffrage, although I do not think they would do any harm with it. And he goes on to talk about the gender division, about political representation in ways that so deeply resonate with Professor Siegel's observations a minute ago. Just over a year later, when speaking to the hardy progressive Jane Addams, and while seeking the nomination for the Bull Moose Progressive Party for president, Teddy Roosevelt said, full-throatedly, without qualification or equivocation, I am for women's suffrage. And I believe within a half dozen years, we shall have no one in the United States against it. And he was pretty close there, right? The math works out nicely. Now, granted, Teddy Roosevelt is making a political statement in each of these. He knows with whom he is speaking. But even such, he found it in his interest to be opposed to women's suffrage in 1911, and then to be in favor of it in 1912. And keep in mind, in 1912, he also endorsed the white primary. Professor Siegel beautifully and sensitively grounded the 19th century conversations about women's suffrage. All I want to do here is genuflect to two critical moments, and that is the 14th and 15th Amendments, which were devastating to the women's suffrage activists. The 14th Amendment enshrined citizenship as a male right and a male privilege, and the 15th Amendment, in one woman's word, established an aristocracy of sex. What that did was to rededicate women's activists around the vote, which was in Seneca Falls just one of a whole range of demands and requests. What it also did was to move attention from the federal level and an amendment to the state level, state by state actions that could bring progress to women's rights. What I'm going to focus on in the next few minutes is one of the relatively unknown strategies that they used in both the state and the federal movements after the turn of the century. And to get you to that, you just need to know or to remember that after the unification of the two organizations in 1890, you're really looking at a leadership around suffrage that's aging. And when Elizabeth Cady Stanton and Susan B. Anthony move off the stage, there's room for a new generation after about 1895. And that new generation is willing to think differently about the visual and political strategies that might be at its disposal. Many of you know that the early victories around suffrage actually occurred out here in the Intermountain and the interior West, with Wyoming in 1869, Colorado in 1893, Utah in 1895, and Idaho in 1896. Those four states granted women's access to the suffrage in a full way. And what I'm going to show you here, and I'll zoom in for you, is one of the first instances we have where the women's suffrage movement turned to maps to make its point and to advance its momentum. Here, and this is a wonderful but much longer story, they were taking cues from both the abolitionist movement and the temperance movement, which had long engaged with maps as visual strategies to reach sometimes marginally and unliterate populations. By the turn of the century, it was even easier to engage in this kind of a mass media movement, and I'm going to show you a little bit about how they did that. To Professor Siegel's point, this map shows you not just the full suffrage rights in the West there, but see all those shaded states. Those are states, if you just glance in the lower right, which had granted women rights to vote in more particular ways, what contemporaries called municipal housekeeping. This simply refers to the way in which women were seen to have just access to issues related to their lives immediately. So think about things related to schools, related to alcohol, and related to taxation and local matters. And so the Women's Journal here is using all those partial victories at the state level to demonstrate that there's momentum that's occurring around suffrage. It's a rhetorical and a political strategy. This technique of using maps absolutely catches fire after about 1909. The next one I'm going to show you gives you a sense of how ubiquitous it is. This is a broadside from 1914, which is absolutely ordinary by that time. People would have seen it all over the place. It is also shows you the changes by 1914, the date of the broadside, and look at all those states here represented in white, which had granted full voting rights to women. So again, the important thing here is the way in which this became a kind of vernacular language for the women's rights movement. So much so that I'm going to show you the backlash that it generated. When the New York Times used a version of this map in a suffrage story in 1913, this was one response. And I apologize if your right screen is cut off, but I'll read it for you. Not a single state east of the Mississippi River has adopted women's suffrage. Every white state on the suffrage map is in the weird and woolly West. Women's suffrage has been adopted only by the crude, raw, half-formed commonwealths of the sagebrush and the windy plains. That's where I live. Whence have come in endless procession foolish and fanatical politics and policies for a generation or two. Now, first, of course, this trades on contemporary perceptions of the West as devoid of civilization, but more important for our purposes is, again, that it references the suffrage map, the sense that this had become a recognizable language of the movement. These maps, like I said, proliferated throughout the early 19-teens as the victories in the West became more and more common. And what they're doing here is exploiting the geography of the movement for a political strategy to show that there's momentum. This reaches the high tide of the strategy in 1915. 1915 is the first, what's referred to as the Empire State Campaign. In other words, it's the first time that New York State considers a statewide amendment to its constitution to enfranchise women. And that was an extraordinary campaign for the uses of these maps. Here I'm showing you just one of the most vivid and compelling examples. At the height of the Empire State Campaign in 1915, Henry Mayer drew this graphic in Puck as a sympathetic portrayal to the women of New York and women really in the eastern half of the United States. You see the representation of Liberation or Columbia as a woman, as a white woman, as she is typically represented in the 19th and early 20th century. And let me zoom in for you. So you can see on her cape, votes for women, and how she's reaching out to the women of the eastern half. And if you squint and look real close on your screen, you'll also see that those women in the eastern half are not just modern in their style of dress and hair, but they're also uniformly white. And this just evokes all the kinds of class and racial divisions that Reva Siegel so nicely underscored in her talk. As I said, the Empire State Campaign was critical. This was the most populous state in the Union, so the victory or defeat of women's suffrage in that state really, really mattered. And the women's suffrage activists distributed 150,000 maps to make their case. They hung them from trees and on fences. They put them in storefronts and on windows, in paper fans. They reproduced them in baseball programs, calendars, drinking glasses. It really is a turning point for the exploitation of mass media for a political purpose within the movement. And in fact, it becomes a problem for the National Association because as they rely more and more on maps and as progress is made state by state, they have to keep updating these maps. And so one of the strategies they do is to make blank template maps available for very, very inexpensive costs and distribute them for local movements to use as they see fit. And like I said, this movement and this representation of women's suffrage through maps becomes so powerful and ubiquitous that it sparks a backlash. Let me show you one of those backlashes again, and I'll zoom in so you can see the proper detail. But here from 1915 is a broadside from the National Association opposed to women's suffrage. And what they say here on the left, let's zoom in. Population votes, not area. You can see their frustration that the women's suffrage map is getting so common, has such currency, and is so widely distributed that people are misunderstanding how the population is actually distributed in this country. I want to draw your attention to a couple of things. First, and this really, again, is borne out by Professor Siegel's talk. Look right under population and you see that what the author has done is to represent each state population. If it's dark, it's represented by man suffrage. If it's white, one of the few white states, and look how tiny they are, relatively speaking, those are states that have engaged in double suffrage. I really love that phrasing, right? That perfectly evokes what Professor Siegel talked about, that women don't need the vote in the 19th century parlance, right? That they are represented through their husbands. This is precisely what former President Roosevelt was voicing as well. They don't need it, although they wouldn't do much harm with it, right? So you have that kind of vernacular, that kind of language, and an attempt to show how little women's suffrage has really progressed if you talk in terms of population. If we go to the right, the other part of the broadside, they've actually taken the most common form of the map. This is the one I showed you just a minute ago from the women's suffrage movement. And they've shown the map very small, but then, and I won't go through the text, but given a full-throated, urgent anti-suffrage explanation that the map, if anything, is deceptive. And based on their reading of population and where women's suffrage campaigns have failed, as the last sentence explains, women's suffrage is going, not coming. Well, in some ways they were right. New York State women's activists suffered a devastating loss in 1915 when the Empire State campaign failed. And part of what that does, as many of my fellow panelists know, was to prompt the reintroduction of the effort at the federal level for a national amendment. State by state movement worked as far as it did, but there was a reassessment with the Congressional Union for Women's Suffrage, led by Alice Paul, and then her effort to move political activism, not just in a state-by-state way, but onto the national stage through the National Women's Party. You can see that here. There's that broadside at the left that I had showed you earlier. And I know it may be cut off for you, but on the right, we have an announcement in 1915 for the reintroduction of a federal amendment, right? And trying to show that the state level momentum supports this idea that more and more people are supporting the national amendment. Alice Paul beautifully used that cartographic strategy on her own terms by announcing in the spring of 1916 a tour of those Western states that had given women the right to vote. And you can see from Washington, D.C., she makes her way through the West, recapitulating some of Susan B. Anthony's tour of the West in 1877, going all those places where women had the right to vote and urging them to use that vote and to join her in the construction of a new National Women's Party. The other way in which the National Women's Party is really important here, you can see this example from my own state of Colorado. When elections come round, you can see the way that the party is asking women to leverage their political power. Women of Colorado, you have the vote. Get it for the women of the nation by voting against Woodrow Wilson. Well, Woodrow Wilson's crime was not really outstanding in this sense. He was one of a majority of men in this country who opposed women's suffrage. But Alice Paul's point was that the Democratic Party was in power. It held both the White House and Congress. And so the party in power must be held responsible. And that to me is a beautiful representation for how social change happens and political change happens on the ground. You can see the way in which this political momentum is shifting. In 1916, of course, Woodrow Wilson prevails in his re-election effort, but this shift is beginning to occur. What you'll notice if you look closely at the House votes when that amendment is reintroduced and debated in 1915 and later years through 1918 is that gradually, in states that move from the anti to the pro-suffrage column, many of those representatives also change their vote as well. So you see the direct relationship between the state level campaigns and the federal movement toward the national amendment. Very briefly, I want to talk about the real tipping point here, and that's the Second Empire State Campaign in New York. In 1917, quite a lot had changed from just 2 years earlier. Look at that left-hand column. All those states in the first half of 1917 had shifted toward allowing women the right to vote at the state level. Lo and behold, many of those are east of the Mississippi, and look at those crucial examples in the Midwest, and the first example we have in the South with the state of Arkansas and partial suffrage. The other thing I want to draw your attention to, and I know it's hard to see, but the blue stamps on here give you a sense of how the postcard in New York was actually used, sent by precinct captains in many of the 5 boroughs to other women who were hopefully sympathetic so that they would pressure their husbands to vote. And in fact, it works in large part because Tammany Hall is on board in 1917 in a way they hadn't been in 1915. And this victory is crucial. New York's victory and movement into the pro-suffrage column sparks tremendous optimism and momentum for the women's suffrage movement, but also an even more intense backlash. I won't dwell on these, but these are just 2 examples of the anti-suffrage Party of New York sending out petitions after the war has begun and making the argument to the US Senate that suffrage in New York and the movement toward a national amendment is actually going to retard the war effort. Dr. Ziegler referenced both the war and the flu pandemic of 1918. I can't tell you how crucial both of those were. It's the war that shifts Woodrow Wilson's support. So he goes from being an opponent of women's suffrage to being a full-throated supporter, in part because the American Women's Suffrage Association, the National American Association, also shifts its support to the war effort. We know that Alice Paul and the National Women's Party remain vehemently anti-war, and that's a more complicated story. But the participation in the war, in the same way that Blacks had supported the war effort in the Civil War, has profound consequences for the momentum. I know I need to wrap up, so I just want to say a few more words about what happens after 1917. That victory in New York shifts the tide, and when the Republican Party wins control of Congress in 1918, it immediately reintroduces the amendment. The amendment passes the House. First, it fails in the Senate, but then some very, very crucial political wrangling occurs in early 1918. And what that does is to shift support for the crucial final vote in June of 1919. And lo and behold, the person who wrangles that final vote is Woodrow Wilson from Versailles while negotiating the Treaty of Paris and sick with the Spanish flu, all those things. So all these things come together. The final thing I want to say, just by way of, for my research as a Civil War historian, is to remember the tremendous irony that's going on, that's palpable here, that as women are gaining the vote in the West and then nationwide, Black men, of course, are systematically losing the vote across the American South in the aftermath of Reconstruction. I thank you for your time and look forward to hearing from the other panelists.
Thank you, Professor Schulten, for those remarks. Next, I would like to hand over the reins to Professor Carolyn Ramsey for her remarks.
Good morning. I hope you're all well. Thanks so much to all of the faculty and staff who pulled together to make this event happen despite the pandemic. After the ratification of the 19th Amendment, the leader of the National American Women's Suffrage Association, Carrie Chapman Catt, envisioned the establishment of a nonpartisan body dedicated to women's political education that would help newly enfranchised female voters develop a voice in public affairs. To this end, Catt guided the conversion of NAWSA into the League of Women Voters. While Catt's goal of training women for full citizenship was abstract, Some state and local leagues took a more practical approach, learning from the experience of tackling specific social problems. My paper analyzes the efforts of the San Francisco Center of the California League of Women Voters and its precursor organizations to reform aspects of the criminal justice system that affected women. In the 4 decades from female suffrage in California in 1911 to the middle of the 20th century, members of the San Francisco Center advocated gender-specific approaches to crime with varying degrees of success or failure. This morning, I'm going to discuss 3 of them. First, prompted to investigate the ills of lower-level criminal courts, known as police courts, by a local judge's mishandling of rape cases, San Francisco Club Women launched a full-fledged effort to establish a women's court. A female judge would preside over this proposed court, assisted by a trained female social worker, and hear cases brought by a female assistant district attorney. Although not every detail of this proposal became a reality, a women's police court was established in 1916, and over the next 15 years, both a female prosecutor and a female judge were appointed. Thus, in a limited sense at least, this reform campaign succeeded. Whether it benefited ordinary women or could really be called feminist is another matter. 2 other significant projects, the longstanding demand for the SFPD to hire police women and the creation of a prison without walls to rehabilitate female criminals, met with endless obstruction and delay, leaving California leaders of the League of Women Voters frustrated with their criminal justice program by the 1950s. I'll start with the origins of the Women's Court. In January 1913, an automobile dealer named Albert Hendricks assaulted a 16-year-old girl. San Francisco Police Court Judge Charles Weller reduced bail for the prominent businessman from $3,000 to $1,000, and during his pretrial release on felony charges, Hendricks fled. The case sparked outrage among women's clubs in San Francisco, and newly enfranchised female voters launched a recall campaign against Judge Weller. Mary Fairbrother, president of the Women's Political League, expressed the view that due to the lackadaisical enforcement of rape laws by judges, young girls are not safe unless they're in their homes. Men of low nature take advantage of their victims' youth and innocence, knowing that they'll probably escape the results of their evil deeds. Although Ms. Fairbrother didn't place all of the blame on Weller, she opined, if he is recalled, the lesson will be a wholesome one to magistrates in the future. A mass meeting of interested women took place, and Weller tried in vain to defend his actions. As news of the Hendricks case spread, it came to light that other alleged rapists had jumped the low bonds that Judge Weller set. The bail amount for many had been under $500 and even as low as $50. Rape complainants, including teenage girls, were required to appear in an all-male setting in Judge Weller's court. Some victim supporters were excluded, and some rape cases had been dismissed on questionable points of procedure. Powerful friends of the judge tried to quash the recall campaign, and both the San Francisco Church Federation and the Labor Council declined to endorse it. But activist women succeeded in obtaining signatures in excess of the 7,000 required to put the matter on the ballot. On May 1st, 1913, Weller's opponent won the special election for his police court position. It was the first recall of a judge in California history. Weller's efforts to deflect blame from himself to the police court system more generally backfired in a couple of ways. Not only was he recalled, but San Francisco Club Women launched an investigation into the evils of the police courts and campaigned to establish a special docket for cases involving women. The San Francisco Center of the California Civic League, the club that morphed into the local League of Women Voters after the ratification of the 19th Amendment, took a more neutral stance on the recall than many other women's groups did. In January 1913, for example, the San Francisco Center held a debate so that both sides could be heard and other solutions to the problems of the police court system could be discussed. Nevertheless, many members of the San Francisco Center supported the ouster of Judge Weller. Despite its relative moderation during the recall controversy, the San Francisco Center actively assisted with the creation of a special women's court in 1916. It sent observers to study the new court's procedure after it became permanent and periodically suggested changes to its operation, including the appointment of a female assistant district attorney. The hiring of Teresa Michael to serve as a prosecutor in the women's court in 1923 was a big milestone, because as San Francisco Center member Rose Wallace acknowledged in a letter on Michael's behalf, a woman in public affairs has to be 3 times as well qualified as a man. The proposed women's court was supposed to play a leading role in guiding prostitutes away from a life of debauchery. Club women wanted to remove female delinquents, especially first-time offenders, from the gaze of men and help them obtain honest employment and medical treatment for venereal diseases. Creating a venue in which the cases of women would be tried away from the scrutiny and hearing of court loungers and habitués was part of the plan. Although the majority of the docket concerned so-called women of the nightlife, the court's jurisdiction would extend to all matters of any kind which involve women as defendants, plaintiffs, or witnesses. Female defendants included those charged with vagrancy, drunkenness, crimes of violence, and property offenses. Dismissals and non-custodial sentences were the most common outcome for victimless crimes. Some male defendants appeared in the women's court too. For example, in 1923, when comedian Fatty Arbuckle faced a murder charge for the death of an actress and fashion model whom he allegedly raped at a bootlegging liquor party, his case got transferred to the women's court for arraignment. The celebrity case packed the venue with cameramen anxious not to miss a single photo, in marked contrast to the regular procedure of the women's court, which typically denied males entrance unless they were relatives of the women on trial. The keen interest of the San Francisco Center in the women's court arose from concern about social hygiene, as it was called. In the 1920s, this local League of Women Voters was more active than the state organization in investigating the availability of free clinical care for sexually transmitted diseases, the role of education in making prostitution unpopular, and the question of whether men and women should be held equally accountable for sex offenses. Writing around 1931, Rose Wallace, a frequent observer of the women's court, overconfidently expressed her view that although immorality couldn't be completely eradicated, she thought that in another generation, there will be very little prostitution. In the late 1920s, a major reorganization of California courts loomed. Turning its attention from the police courts, the San Francisco Center pinned its hopes in 1930 on the prospect that one of the women attorneys practicing in the city and county of San Francisco would be appointed to the newly established municipal bench. The strategy paid off. Teresa Michael, the former women's court prosecutor, accepted a municipal judgeship overseeing the women's docket. She served several non-consecutive terms and seems to have adopted a more punitive attitude toward female offenders during the later part of her career. During World War II, for example, when the health of soldiers and sailors renewed governmental concern about female vice, Michael earnestly promised a crackdown on streetwalkers, whom she said should be given jail terms. By this time, the women's court was located in the health center on Kearny Street and exclusively handled morals offenses, while wife beating and other domestic crimes, including a husband's failure to provide, were tried at the Hall of Justice. Some municipal judges and prosecutors favored combining these dockets into a single judicial department in one physical location, a controversy that extended into the 1950s. Proponents of the move argued not only that it would be more efficient, but also that domestic criminal cases arising out of family difficulties needed more sympathetic care and attention. However, interestingly, the San Francisco club women seem to have viewed the issue solely from the perspective of maintaining a rehabilitative approach to morals cases. There's little or nothing in the papers of the San Francisco Center of the California League of Women Voters from the first half of the 20th century about domestic violence. In the early 1950s, the San Francisco Center actively opposed returning prostitution cases to the crime-filled Hall of Justice, which they regarded as a training ground for new offenders. Even though the location of the women's court at the health center inconvenience judges, the club women argued that the advantages afforded by way of segregation, cleanliness, and opportunities for rehabilitation should not be sacrificed. Like the National League of Women Voters, the San Francisco Center involved itself in a variety of social welfare issues, advocating child labor legislation, for example. Yet in its criminal justice agenda, it doggedly pursued one central issue: the rescue of fallen women. Even after the term social hygiene, which evoked an outdated focus on venereal disease, led to the choice of a new label, the study and prevention of delinquency, the San Francisco Center focused on the goal of separating female delinquents from predatory males and other female offenders, the older repeat offenders who were considered to be a menace to the young. Well-heeled club women whose names appeared in society columns devoted to news about summer retreats and elegant parties believed that the origins of delinquency could be found in improper home environments. They often laid the blame at the doorstep of poor and foreign parents. Their analysis of the problem, and hence their chosen solutions, thus had race and class dimensions. In short, the San Francisco Center continued to hold values that echoed the moral purity campaigns of the late 19th century, despite being imbued with an ethos of social scientific study and data reporting that reflected its progressive era origins. The problem of domestic violence, which failed to make the League of Women Voters priority list, got a similar legal response in the first half of the 20th century as it had in the 19th. California judges used an array of criminal penalties from fines and suspended sentences to incarceration for wife beating. In several cities across the nation, misdemeanor cases actually began to be handled by domestic relations judges who could still order criminal penalties. Assaults were charged as felonies, which typically involved the use of a deadly weapon, were handled in superior court, and these led to long prison terms for male offenders and increasingly for women as well. Although such a system featured more state intervention in the family than many feminist scholars acknowledge today, it was neither effective nor grounded in principles of gender equality. So the League of Women Voters' failure to develop a reform agenda to confront domestic violence directly constituted a significant oversight. A second project dear to the club women was their persistent effort to persuade the SFPD to hire female officers. This project exemplified the way progressive tools might perpetuate essentially Victorian values. Spearheaded at first by other groups, including the Women's Christian Temperance Union, the campaign to allow women to serve on police forces attracted the support of the San Francisco Center by 1915. The chief of police flattered the suffragists by writing, "The advent of women into the political life of California has had a marked effect on the operations of police departments. In San Francisco, we have 3 women protective officers who have labored with success in the preservation of law, order, and morality." The San Francisco Center's corresponding secretary wrote to the police chief repeatedly, urging him to make budget allocations to hire additional police women for the work among women and children. Female officers were thought to be especially well suited to preventive policing tactics, such as the referral of dance hall girls for medical and psychological diagnosis. Unlike male police officers, police women might succeed in keeping women's cases out of court so that they could be taught right and wrong without being thrown into the county jail. However, despite the police chief's praise for the healthy interest in public affairs that newly enfranchised California women exhibited, the SFPD proved to be firmly set in its opposition to gender diversity for the next several decades. In the mid-1920s, San Francisco club women proposed the creation of a police women's bureau, like the ones already established in Washington, D.C. and several other cities. Ideally, the proposed unit would be headed by a female supervisor. A speaker told the San Francisco Center's Committee on Delinquency that San Francisco needed not fewer than 21 police women. But in 1926, the president of the Police Commission delivered the bad news that traffic officers and traffic signals were higher priority, and it couldn't all be done this year. The SFPD still had only three policewomen in the 1930s. Motivated to participate in the National League of Women Voters civil service reform campaign, which opened unprecedented paths to jobs and community involvement for women, the San Francisco Center renewed its focus on getting trained women with a background in social work hired by the SFPD during World War II. After decades of failed efforts to bend the ear of top police brass, Harriet Allele, a prominent figure in state and local league affairs, complained in 1943, San Francisco still has no policewomen in the best sense of the term. In April 1944, the personnel director for the city and county of San Francisco informed the club women that 27 out of 29 applicants to be Class Q20 policewomen lacked qualifying experience. Only 2 were referred for further medical and character examination. The next month, an official Civil Service Commission bulletin, printed on pink paper, of course, again announced hiring opportunities for female officers, but only for the duration of the war and not more than 6 months following the cessation of hostilities. In fact, throughout the 1950s and 1960s, the SFPD officers patrolling San Francisco streets continued to be predominantly Catholic and white and exclusively male. The 8 policewomen assigned to the department at mid-century only worked on juvenile and sex cases, and I think such segregated work was at least partially attributable to the San Francisco Center's limited vision. The tiny band of female officers couldn't wear uniforms or interview adults, not even rape victims. A third initiative, the club women's effort to establish a prison without walls to rehabilitate female offenders, also ran up against formidable impediments. The founding of a reformatory for convicted women in the grassy foothills near Tehachapi was a more revolutionary conception than most of the California League of Women Voters' criminal justice projects in the first half of the 20th century. But it also led, at least initially, to one of their greatest debacles. The proposed institution would house female offenders in buildings with red tile roofs, where they would sleep in bedrooms rather than cells. Handicrafts and farm work would occupy their time. The fertile land promised to large yields of potatoes and other crops that would allow inmates to grow their own food. They could also complete their education and learn a trade. The California League of Women Voters and local branches like the San Francisco Center ardently supported this experiment, and Rose Wallace, who had since moved to Los Angeles County, provided important leadership. But in 1932, after the Tehachapi facility had been fully funded, built, and staffed with a female director to the tune of a $500,000 bill for California taxpayers, prison officials balked. Under the state constitution, 120 female inmates scheduled to be transferred to the new women's prison had to stay in San Quentin. Without walls or fences, the new facility did not satisfy the definition of a prison. Moreover, the legislature lacked authority to pass a bill that transferred control over female inmates to a special board of directors, the majority of whom were women. Eventually, a 12-foot fence was built, and under the supervision of men, Tehachapi became just another prison. In 1936, California voters returned the direction of the women's facility to women's hands by creating a board of trustees independent of San Quentin. The Tehachapi Women's Prison operated with a largely female staff until an earthquake destroyed it in 1952, and female offenders began to be incarcerated elsewhere in the state in prisons that certainly didn't meet the rehabilitative ideals of the California League of Women Voters. Now, historians have criticized the National League of Women Voters for failing to brandish the banner of feminism in the years after the ratification of the 19th Amendment. The League opposed an Equal Rights Amendment for much of the 20th century, and its nonpartisan embrace of general social welfare programs and international peace and cooperation eschewed a radical platform that might have brought sex equality to the fore of American politics. As my paper has shown, San Francisco members who dedicated their energy to criminal justice reform at the state and local level took a more gender-specific tack. They saw the need not only for women-specific institutions, but also for female lawyers, police, and other criminal justice personnel to enforce morals and rehabilitate female criminals. Yet the San Francisco Center embodied the vision of affluent white women, and with the exception of the Tehachapi experiment, employed progressive tools to achieve fundamentally conservative solutions to crime. Club women in San Francisco extended the Victorian obsession with moral purity into the 20th century with their myopic focus on prostitution and other forms of vice. While recognizing, for example, that female delinquency stemmed from child neglect, poverty, domestic violence, and other trauma, they left 19th century approaches to offenses like wife beating largely unchallenged. Thank you.
Thank you so much, Professor Ramsey. Next, we will hear from Professor Julie Sook.
Thank you so much. I just want to thank the organizers once again for keeping this event going. As many of you may know, in the centennial year, something very important historically was happening that we were focused on in January and February, which is that Virginia became the 38th state to ratify the Equal Rights Amendment to the US Constitution, and the House voted in February to extend the deadline on ratification. And there was an intense debate that was bubbling up about what this could mean, whether or not the ERA could actually become part of the Constitution now. And the ERA was, of course, introduced on the heels of the 19th Amendment. And I'll be speaking today from parts of a book that I'm writing about the 100-year history of the Equal Rights Amendment. And you can think of the project as taking up Professor Siegel's challenge to think of women as constitution makers. What would it mean if we were to conceive of women as founding mothers of the Constitution, on par with the founding fathers of the Constitution, by looking at the women who brought us the 19th Amendment and the women who've been struggling for 100 years for the Equal Rights Amendment as constitution makers and as mothers of the Constitution. So with that in mind, I'm going to start. I have slides which I think will be helpful, because one of the things that I think that we're so familiar with in our constitutional space is this idea that, sorry, I have to get the share screen going. Okay. Great, so it's taken from my book, We the Women, which will be out this summer, definitely in ebook format, and also when bookstores open in print format as well. And if we could look at the Equal Rights Amendment, and this is the version that's being ratified, or that completed ratification earlier this year, Section 1, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. It's a general guarantee of equality, and the text has been changed since the time that it was introduced in 1923 in Congress. And many of the proponents of the ERA, when it was first introduced in the early 1920s, believed that the Constitution should guarantee women's equal rights, not only as voters, but as full persons and citizens. And it took Congress, of course, 49 years to actually adopt this amendment in 1972. And the fight for ratification in the states took another 48 years, culminating in Virginia's historic ratification in January of this year. And as I mentioned, even with all of the ratifications complete, the ERA's future is uncertain because Congress imposed a 7-year deadline on ERA ratification in 1972, which was extended to 10 years, but that too expired in 1982. And the House voted recently to remove the deadline, and it remains to be seen whether the Senate will follow. And certainly one of the arguments that's made on many sides of the political spectrum is that it's too late to ratify the ERA, and that we don't really need the ERA, echoing, I guess, some of the language that I heard in Susan Schulten's talk about the idea that we don't need the 19th Amendment. In any case, one thing that's very interesting about the parallel, not just the temporal proximity between the ERA and the 19th Amendment, but there's an important, I'm sorry. Can everyone still hear me? Okay, so I was getting I'm sorry, I was getting a strange message from Zoom, but I'll continue. So since Prohibition, there has only been one amendment to the US Constitution that's had no deadline, and that's the 19th Amendment. And with good reason. The 19th Amendment was actually ratified within the 7-year time frame, but it actually took 70 years of introducing the 19th Amendment in Congress before it was actually adopted and sent to the states for ratification. The transgenerational struggle for the 19th Amendment is actually importantly connected to the transgenerational struggle for the ERA, because understanding these intertwined histories is actually important to the moral and political case for ratifying and remaking the meaning of the ERA, notwithstanding the deadline in the 21st century. And it draws attention to the transgenerational nature of the struggle for women's rights generally, and the transgenerational struggle that's required every time we try to expand the constitutional vision of who's included in we the people. And we can begin actually in understanding that transgenerational struggle with Abigail Adams. Abigail Adams, as Professor Ziegler mentioned in her keynote, was the wife of John Adams, one of our founding fathers of the Constitution. And she wrote in a letter to John, as he was on his way in 1776 to the Continental Convention, to remember the ladies as they were writing a new code of laws. And she said, "Do not put such limited power in the hands of the husbands. Remember, all men would be tyrants if they could. If particular care and attention is not paid to the ladies, we are determined to foment a rebellion and will not hold ourselves bound by any laws in which we have no voice or representation." Of course, John Adams and the founding fathers did not remember the ladies. When they wrote the Declaration of Independence that summer, they said all men are created equal. But future generations of women listened. They actually did foment a rebellion. It was not the same kind of rebellion involving guns that the American Revolution entailed, but the revolutionary spirit was there, and the rebellion that was fomented was one that played by the rules of the Constitution itself, Article 5. And because Article 5 makes the Constitution so difficult to amend, requiring 2/3 of both houses of Congress elected for much of the history of the 19th Amendment, primarily by men, and ratification by 3/4 of the states. Again, state legislatures elected primarily by men by the time that the 19th Amendment is ratified. It's understandable why efforts to expand who's included in We the People take so much time when the rebellion is fomented by way of an Article 5 amendment as opposed to other means. And of course, the words that Abigail Adams spoke are part of the 21st Century Equal Rights Amendment as well, because the 21st Century Equal Rights Amendment involved the ratification by state legislatures in Nevada, Illinois, and Virginia in the last 3 years. In all of those legislative debates, Abigail Adams' words about remembering the ladies has been quoted. Those words have been quoted by the legislators who have been leading the ratification efforts. And so transgenerational meaning has been produced in that way. And over 100 years after she wrote these words to John Adams, and in fact 60 years after her death in 1818, the first bill to propose the constitutional amendment on women's suffrage was introduced with hearings in 1878 and in 1880. And we have Susan B. Anthony by this time active in the women's suffrage movement, and in testifying before Congress on the women's suffrage amendment, she said, "We women have been standing before the American Republic for 30 years, asking the men to take one step further and extend the practical application of the theory of equality of rights to all people to the other half of the people, the women." And so she was in a hearing before the Senate Judiciary Committee when she talked about equality of rights. That is, suffrage was supposed to be one piece of this broader vision of equal rights for women. And that broader vision had actually been declared 30 years before the first amendment for women's suffrage was actually introduced. And when the broader vision of equal rights was declared at Seneca Falls in 1848, there was a plank for women's suffrage. But interestingly, in 1848, women's suffrage was considered the more radical proposition. So much of what was declared at Seneca Falls involved equal rights that would end the institutions of coverture. And indeed, Lucretia Mott's resolution that called for securing to women equal participation with men in the various trades, professions, and commerce. Lucretia Mott's resolution became the basis of the Equal Rights Amendment that was introduced decades later. And in fact, by the time that Susan B. Anthony, in the year that Susan B. Anthony spoke these words about standing before the American Republic for 30 years asking for suffrage, Lucretia Mott died in that same year. And Susan B. Anthony, while she struggled for suffrage for much of her adult life, excuse me, I'm not sure what's going on with that. I apologize for that intervention. So Susan B. Anthony was actually dead by the time the 19th Amendment was ratified. And so was Elizabeth Cady Stanton, who was a founding mother at Seneca Falls in 1848. And so the story that can be told about suffrage, as with the Equal Rights Amendment, is that there are generations of women struggling who do not live to see the fruits of their constitutional labors. Indeed, when Elizabeth Cady Stanton, also in 1878, testified before Congress in support of the constitutional amendment on suffrage, she asked, does anyone pretend to say that men alone constitute races and peoples? When we say parents, do we not mean mothers as well as fathers? When we say children, do we not mean girls as well as boys? When we say people, do we not mean women as well as men? So the 19th Amendment was made by women who struggled for decades and did not live to see the fruits of their labors. And it's really by 1920, or rather by the time that both houses of Congress in 1918 and 1919 finally get around to adopting the 19th Amendment by 2/3, you get success because of World War I. And we're finding out today, as we're looking more closely at the history, because of the flu pandemic that followed World War I, that led to the deaths of so many men and shed new light on the essential role of women, especially working women and mothers in a democracy. Anna Howard Shaw, when she testified in favor of the suffrage amendment, said that the time of Reconstruction will come, and many women of this country will have to be both father and mother to fatherless children, and these women and their children will have no representatives in this government unless they're represented through the mothers who have given everything that the government might be saved and democracy might be secured. That is, World War I and the flu pandemic really brought out the need for women to be in the public sphere, working in unprecedented numbers, while also carrying on the care work that was essential to the reproduction of the nation. That's what was meant when Anna Howard Shaw said that women were becoming mother and father, both caregiver and breadwinner. And so we got the 19th Amendment then with women still talking about the legitimacy of democracy and what democracy would mean if it continued to deny half the people the right to vote. And Susan B. Anthony's torch and that of Lucretia Mott and the earlier generation was carried on for generations. One important legacy of suffrage, of course, was the introduction of the ERA. And the National Women's Party, led by Alice Paul, Crystal Eastman, and lawyer Bernita Matthews, worked on the Equal Rights Amendment. Bernita Matthews, of course, went on to become the first federal trial court judge in 1949. When the Equal Rights Amendment was introduced in 1924, Crystal Eastman explained in the New Republic that the ERA would accomplish three things. First, that it would sweep away any common law precedents that made women dependent on and inferior to men. Second, it would be a Bill of Rights against sex discrimination. For instance, a woman teacher would have the right not to be fired from her job upon marriage. Third, it would mean that industrial legislation could not treat women workers as children or minors. And this really gets to the heart of the conflict. Eastman was actually one of the co-drafters, along with Alice Paul, of the Equal Rights Amendment. And she was very firm in all of her writings about the ERA that protective legislation that was genuinely protective of women workers would probably be extended to include men, and thus all element of tyranny removed from it. But despite her vision of what the Equal Rights Amendment would do, there was considerable division even within the National Women's Party about what it would mean. And in 1923, the same year that the Equal Rights Amendment was actually introduced, the Supreme Court decided Atkins versus Children's Hospital. This was a case that held that minimum wages for women only violated the 14th Amendment, recognizing at long last women's freedom of contract. The court, though, premised the decision on the 14th Amendment, but cited the newly ratified 19th Amendment to suggest that women now enjoyed equal status to men and therefore no longer needed any special labor protections. In view of the great, not to say revolutionary changes which have taken place, the Supreme Court wrote, in the contractual, political, and civil status of women, culminating in the 19th Amendment, it is not unreasonable to say that these differences have now come almost, if not quite, to the vanishing point, unquote. That's why most women's groups actually opposed the ERA, including the National American Women's Suffrage Association, which morphed into the League of Women Voters. They were really afraid that the ERA would stop treating women differently for the purposes of labor legislation, such as minimum wages or exemption from overtime for women only. And many of the women's groups who had worked on suffrage actually opposed the ERA for this reason. Their focus right after the war, as Professor Siegel mentioned earlier, was the Shepard-Towner Maternity Act. They wanted to have legislation that would address maternal and infant mortality, and they worked with and were part of the Women's Joint Congressional Committee in trying to make that legislation move forward. Now, after Atkins, it was clear that we were dealing with a federal judiciary that was generally hostile to labor rights and was likely to use the ERA in the way that it cited the 19th Amendment in Atkins, visions of gender equality, to extend a vision of labor hostility to both men and women alike. And for fear of this, there were social feminists, including Florence Kelley, who was the head of the National Consumer League, and the invisible force in many ways behind Muller versus Oregon, the precedent that had actually upheld special labor laws for women only. Florence Kelley testified throughout the 20s against the ERA because she was afraid that the judiciary would use it to strike down labor laws in the way that the judiciary cited the 19th Amendment in Atkins to strike down the minimum wage for women. As Kelley described it, Atkins protected the inalienable constitutional right of American women to starve. And so the opposition to equal rights that you see in the 1920s amongst people who had supported and worked hard for suffrage really comes from a concern about judicial enforcement of the Equal Rights Amendment and a vision of women's equal rights that really depends on women's empowerment through legislation, including social programs like Shepard-Towner that focused on issues that would reduce women's disadvantage. And I think now, if you also look at Dorothy Kenyon, Dorothy Kenyon later went on to argue sex discrimination cases for the ACLU. She also opposed the ERA in the 1920s and 1930s because she said that the ERA could function like a blind man with a shotgun. And it was these concerns about the existing judicial context, where in fact there were very few, almost no women judges, that there was concern that the ERA would not actually fulfill Crystal Eastman's vision of something much more expansive and something that would actually address the disadvantages faced by women because of their role in both biological and social reproduction. And so on the one hand, we think a lot when we think of women in constitution making as having a story of division, women not coming along with the Equal Rights Amendment and focusing on other agendas. But I want to actually suggest that even women like Dorothy Kenyon and Florence Kelley, and later Mary Church Terrell, who in the 1940s brought the National Association of Colored Women support for the Equal Rights Amendment in hearings in the 1940s, that a lot of these women who debated about the ERA and didn't wholeheartedly support it at the beginning could also be seen as constitution makers who gave meaning to the ERA, because the debate that they engaged in actually created a productive postponement so that the ERA got passed on to the next generation, and the next generation, as we moved into the 1970s and certainly into the 21st century, had a more nuanced understanding of the ways in which women were disadvantaged, particularly working mothers, because of their role in social reproduction. And therefore, we needed a vision of the ERA that would be more robust than a judicial vision that would involve striking down any laws that treated men and women differently. And I think it's important on the centennial of the 19th Amendment to recover this history as we think about the transgenerational construction of the meaning of the ERA. We often hear that the ERA is no longer needed because we've gotten everything that the ERA was supposed to achieve through the 14th Amendment. But one thing we have not gotten through 14th Amendment jurisprudence made by lawyers and judges, one thing we have not gotten is full recognition of the ways in which advocacy for women-specific amendments, sex-specific amendments like the 19th Amendment and also the ERA, have really transformed women into constitution makers and have created a discourse that should be part of the way that we understand what the Constitution does and means in the 21st century. Thank you.
Thank you so much, Professor Suk. Finally, we'll hear from Professor Ziegler.
Thanks, and thanks everybody for organizing this. It's amazing that anyone organized anything during the pandemic, so I'm impressed and grateful. I was struck in writing this paper about what happened at this year's March for Life, during which organizers, abortion opponents, focused on the 19th Amendment and women's suffrage in framing their own cause. And in part, this might not have been surprising, as Reva Siegel's written woman protective arguments against abortion have a history and have been around for a while. And so too have arguments that famous suffragettes themselves opposed abortion, probably most notably Susan B. Anthony. What was more surprising to me was that these arguments were back with a vengeance after they had seemingly been rejected by the US Supreme Court, or at least related arguments were in Whole Woman's Health versus Hellerstedt in 2016. When such arguments were being rejected with growing force by the medical community, including the American Medical Association, and perhaps most interestingly, when these claims were being rejected by leaders of the anti-abortion movement in the States, which had moved largely beyond woman protective arguments towards some of the bills that are familiar to us from last summer, including bills that banned abortion when a fetal heartbeat or fetal cardiac activity could be detected, or bills that banned abortion outright, including those that are now becoming familiar during the coronavirus pandemic. So in this paper, I wanted to think more about why the equality wars, the idea that in the context of abortion, abortion opponents are the true inheritors of the legacy of the 19th Amendment, and those who truly speak for women's equality, why those continue to rage on, notwithstanding the reasons that abortion opponents would have many reasons for giving up on those arguments and moving toward the fetal rights arguments that had in many ways been the bread and butter of the movement from the beginning. So in telling that story, I'm going to trace some of the history of anti-abortion arguments based on the 19th Amendment and women's equality going back to the 1960s and tracing them to the present, thinking too about what a focus on equality, at least the different visions of equality by those on both sides of the abortion debate, has meant for where we are in contemporary American abortion politics. So the American abortion conflict didn't have a lot to do on the anti-abortion side with the effects of abortion on women at the beginning, although claims about abortion's harm on women dated back to the 1960s. How this came about was that the early abortion reform movement, often led by physicians, centered on claims that criminal abortion laws denied patients the best quality of care, essentially hamstringing doctors who would otherwise have performed abortions they felt were the best for their patients' physical or mental health. Anti-abortion scholars, many of them with no medical background, insisted in response that abortion itself would harm women's psyches and damage their fertility, essentially because women themselves were designed to have children and that abortion was a violation of women's true nature, both as child bearers and child rearers. For the most part, though, these arguments were a sideshow to what was the growing identity of a movement that defined itself by virtue of a right to life that proponents identified both in the Declaration of Independence and in the 14th Amendment of the Constitution, in particular the Equal Protection Clause and Due Process Clauses of that amendment. The right to life movement, in many ways, as it saw itself, insisted that abortion was both unconstitutional and immoral, really irrespective of its consequences for women. And so invoking the 19th Amendment for this movement would have seemed incongruous, if not a bit perverse. Of course, feminists who supported the repeal of all abortion restrictions, including Betty Friedan, framed abortion not only as a civil right for women, but one that would have powerful concrete consequences as women sought to achieve more equal citizenship. In many ways, Friedan understood that there could be a direct line drawn from the 19th Amendment to the kind of abortion repeal that she and other feminist leaders envisaged. After Roe, at first, relatively little changed on the anti-abortion side. Indeed, larger anti-abortion organizations like the National Right to Life Committee focused almost entirely on a constitutional amendment that would ban all abortions coast to coast, including those performed by private actors. And most leading anti-abortion organizations had relatively little time for claims involving women. There were always exceptions. Feminists for Life, organized in 1973, and quite early on made claims about the anti-abortion views of suffragettes, and also made arguments essentially that abortion was both a violation of women's true nature and an excuse for men to exploit women sexually without undertaking their own fair share of care work. Other anti-abortion organizations, including Women Exploited by Abortion, founded in 1983 by evangelical Protestant women, Project Racial, formed this next year by Catholic women, and American Victims of Abortion, which was organized under the umbrella of the largest national organization, National Right to Life Committee, focused on helping women who claim to regret their abortions or be traumatized by them. And larger national anti-abortion organizations were happy to have these organizations, but largely kept them on the sidelines, viewing their arguments as of secondary importance. We can see the seeds of women protective arguments early on, though, in two cases that could have been pivotal. The first, City of Akron versus Akron Reproductive Health Center, grew out of the Supreme Court's first major abortion decision after Roe, a case called Planned Parenthood of Central Missouri versus Danforth. For abortion opponents, the striking thing about Danforth was that they didn't lose entirely, which is what everybody had been expecting. Danforth, in fact, upheld what lawmakers in Missouri called an informed consent law, requiring women to give written consent before having an abortion. Abortion opponents, particularly the group Americans United for Life, which focused on anti-abortion public interest litigation, helped to draft a much more controversial informed consent law, including highly disputed, scientifically questionable statements about the effects of abortion on women's mental health and fertility. Along with this new beefed up informed consent law, Americans United for Life introduced a new constitutional approach, insisting that abortion restrictions should be constitutional unless they were quote unquote unduly burdensome. As AUL saw it, if an abortion restriction in fact helped women, for example, by helping them make more informed decisions, then it should be considered constitutional. In other words, effects on women became a vehicle for restricting abortion rather than enhancing access to it. The Supreme Court at the time, of course, had changed very little since Roe v. Wade and rejected the argument in Akron, further dashing the hopes of those who had hoped to make women protective arguments a centerpiece of anti-abortion advocacy. Americans United for Life tried again in the late 1980s in a case called Turnick versus Ragsdale, which grew out of a controversy in the Chicagoland area when the Chicago Sun-Times ran an expose on subpar standards of care in some of the area's abortion clinics. The state legislature responded with tough regulations, some of which would resemble what we would call a trap law or a targeted regulation of abortion providers. Dr. Ragsdale, who wanted to build a new clinic, filed suit arguing that he would be functionally unable to do so, and that the regulations writ large violated the rights of patients to seek abortions under Roe v. Wade. Ragsdale appeared poised to go to the Supreme Court, which had granted cert to hear the case, and Americans United for Life viewed it as a promising tool, a way, as activists saw it, to separate abortion providers who could be demonized as greedy profiteers and women who could be valorized both as patients and mothers who had simply chosen abortion because they had been misled. But Ragsdale was settled in part because Illinois' Attorney General, a Democrat, had ambitions to run for governor and didn't really want to be pursuing a lawsuit on behalf of the anti-abortion movement in a highly Democratic state. And at the time, in the lead up to Roe, there was very little reason most anti-abortion leaders saw for focusing on the equality wars or invoking the 19th Amendment. In part, fetal rights arguments, of course, had been what had brought many to the anti-abortion movement in the first place. And this was all the more true in the late 1980s when the movement was in many ways defined by Operation Rescue and efforts to blockade abortion clinics. As Operation Rescue embodied, many grassroots anti-abortion activists simply didn't believe that women were victims, and that while they may have accepted the argument that women were naturally mothers and that women violated their true natures by having abortion, they still portrayed women who chose abortion as murderers and perpetrators, not as victims deserving sympathy. This began to change somewhat the influence of women protective arguments in the immediate lead up to Planned Parenthood versus Casey, the court's 1992 landmark decision, which preserved abortion rights. Internal polling by major groups like Americans United for Life and the United States Catholic Conference indicated that most Americans believed that abortion opponents were anti-woman and didn't like that. In fact, were more likely to favor abortion rights because of their views of what they saw as anti-abortion extremism. So a softer image, many in the anti-abortion movement thought, was overdue. The most important piece of the story in terms of the rise of arguments involving the 19th Amendment and equality for women on the anti-abortion side came in Casey itself, though, and those arguments have everything to do with the mission to undo Roe v. Wade. The two most influential, in my view, legal organizations in the anti-abortion movement saw different things in Casey that they thought made women protective arguments crucial. The National Right to Life Committee seized on part of Casey, focusing on the legitimacy of the Supreme Court. Casey, and rather unusually, insisted that were the court to overrule Roe under fire, as the justices put it, that might irreparably damage the court's reputation for being above the political fray. National Right to Life Committee attorneys read this as an admission that the court feared a popular backlash if Roe were overturned and the American public disapproved. The goal then, as National Right to Life Committee attorneys saw it, had to be to convince the public that it would be okay if Roe were to be decimated. How would this be done? Anti-abortion attorneys in the organization insisted that Americans had to be convinced that abortion was no longer a necessary evil. That was to say that women neither wanted or needed abortion if they understood what it truly did to them. Americans United for Life focused on a different dimension of the Casey opinion, one involving reliance. The Supreme Court will often hesitate to overrule precedents that have generated substantial reliance interests, most often in business transactions where parties have planned commercial arrangements long in advance. Of course, abortion didn't really fit this paradigm because women often didn't plan pregnancies at all, much less in advance, or even in the case of wanted pregnancies, faced unexpected circumstances that made them reconsider whether to continue a pregnancy. Nevertheless, the court found that there were reliance interests in Casey, suggesting that women had relied on access to abortion in achieving more equal citizenship. Americans United for Life believed that if their movement could show that women neither could nor should rely on abortion, that the foundation for Casey, Roe, and abortion rights in their entirety would crumble. So after Casey, a woman protective argument almost exploded onto the anti-abortion scene. The leading initiative after Casey at first were informed consent laws patterned almost identically on the one the court had upheld, but quite quickly, women protective arguments became a new source of disagreement in the anti-abortion debate. as anti-abortion organizations made increasingly controversial and contested claims about science. Americans United for Life launched what it called the Abortion Breast Cancer Campaign. This campaign relied on earlier studies suggesting that women who terminated a pregnancy had a higher risk of getting breast cancer lifetime. But by the mid-1990s, research published in the New England Journal of Medicine had led cancer organizations from the American Cancer Society to the National Institutes of Health to conclude that there was no correlation between abortion and an increased risk of breast cancer. Nevertheless, Americans United for Life used an abortion breast cancer connection to advance arguments about equality for women and opposition to abortion, suggesting that any true supporter of women's equality and any true proponent of something like the 19th Amendment would oppose a procedure that even had the possibility of injuring women. Scientific uncertainty then, as anti-abortion activists saw it, militated in favor of protecting women from abortion. Similar arguments actually found their way into the partial birth abortion campaign of the 1990s and early 2000s, which of course, ironically, at least on its face, had almost nothing to do with women. It was heavily centered on fetal rights and late-term abortions. But abortion rights organizations and obstetricians insisted that a ban on the disputed procedure, dilation and extraction, would have damaging effects on women's health. In disputing the need for a health exception, abortion opponents insisted that scientific uncertainty again broke the tie for them. Abortion opponents identified their own sources of expertise and evidence, often founding organizations that hadn't previously existed, to assert that partial birth abortion was not only unnecessary, but also unsafe. These organizations also began working with dissenting groups in the anti-abortion movement that had grown tired of the slow pace of change pursued by larger groups. Harold Cassidy, one of the champions of this approach, had become famous in surrogacy cases, including the Baby M case of 1986, representing surrogate mothers who wanted to reestablish connections with their children. Cassidy believed that the court would reverse Roe if it understood that abortion, in fact, denied women rights to have or preserve a relationship with their unborn children. In other words, Cassidy thought banning abortion was the only way to vindicate the kind of right that had been embodied in the 19th Amendment. Cassidy saw the mainstream group's strategy as unnecessarily cautious, and was in fact contacted for this reason, or at least partly for this reason, by Norma McCorvey, the Roe of Roe v. Wade, and Sandra Cano, the Doe of Doe v. Bolton. Cassidy passed these requests on to Alan Parker, the founder of the Conservative Justice Foundation in Texas, and Parker launched a project to document what he saw as widespread regret by women like McCorvey and Cano who had had abortions. At least for a time, though, a woman protective argument united different factions in the anti-abortion movement, particularly in the litigation of Gonzalez versus Carhart. As Reva Siegel and others have shown, the court in Gonzalez relied heavily on a brief created by the Justice Foundation's Operation Outcry and concluding that women regretted abortions, and using the testimonials of these women without any other research to establish that there was at a minimum common sense assumption that women regretted abortion, and that there was at least scientific uncertainty about whether partial birth abortion was necessary to preserve women's health. So after Gonzalez, it was no surprise at all that organizations across the anti-abortion movement, including dissenting ones, embraced women protective claims. What's more puzzling is why these claims have persisted in recent years, and that's the case for three reasons. Probably the most obvious is the court's 2016 decision in Whole Women's Health. Whole Women's Health involved Texas's HB2, which had two relevant provisions. One that required doctors to have admitting privileges at a hospital within 30 miles of the clinic, and a second which required abortion clinics to comply with the regulations governing ambulatory surgical centers in the state. Estimates by researchers in and outside of the state of Texas suggested that almost all of the state's clinics, with only a handful remaining, would be forced to close if the regulations went into effect. The court in Whole Women's Health seemed highly skeptical of women protective arguments, suggesting that neither of the regulations proposed by Texas had any benefit whatsoever, and further indicating that abortions were safe in general, not just only in Texas or in the limited circumstances of the case. Holman's help then, in its immediate aftermath, led experts to wonder if anti-abortion organizations would abandon woman protective arguments entirely in favor of the fetal rights arguments that still seem to resonate the most deeply with movement leaders. The science underlying women protective claims has continued to be denounced by medical authorities. Perhaps the most pronounced move in this direction came with so-called abortion pill reversal laws. In recent years, an increasing share of abortions involve the use of a 2-pill abortion protocol. And this is likely to become even more true in a world where many activists are pursuing or at least demanding access to telemedicine abortions. In response to the rise of abortion pills, abortion opponents introduced informed consent statutes telling women that they could reverse abortions if they, in between taking the first and second pill, if they took large doses of progesterone. The problem was that there was almost no research suggesting that this progesterone treatment would be either effective or safe, and in fact, early research on the subject suggested that it would be quite dangerous for patients. Nevertheless, anti-abortion activists continued introducing informed consent laws of this kind. But for the first time really that I've seen as a historian, the American Medical Association sued, arguing that these laws violated the First Amendment rights of doctors and damaged the health of patients. Perhaps most strikingly, even in the states with strong anti-abortion legislatures, there's been very little interest in women protective arguments, especially since the elevation of Brett Kavanaugh to the Supreme Court. Instead, legislatures have returned with considerable force to the fetal rights arguments that have long defined the movement, introducing statutes that ban abortion at 6 weeks when fetal cardiac activity can be detected, or banning abortion outright from the moment of fertilization, or banning abortion and recognizing fetal personhood. These laws, I think, in many ways reject both the incrementalism of the anti-abortion establishment, but also its recent focus on supposed harm to women. So why are the equality wars still with us, and why are we seeing anti-abortion groups invoke the 19th Amendment after so many reasons for abandoning that argument? I think it's because the movement still has a single-minded focus on overturning Roe, and abortion opponents recognize that it's hard to imagine an overturning of Roe that would last, regardless of who's on the Supreme Court, if most Americans believe either that abortion is necessary for women's equality, or at the very least that abortion is a necessary evil, as abortion opponents would frame it. I think it also tells us something important about the nature of disagreement in American politics. On the surface, the fact that we're having a war about what helps women's equality or who is the true torchbearer for the 19th Amendment would suggest that we're agreeing on more, right? That equality for women is something, in theory, people on both sides of the aisle can agree about. What in fact has happened is that there's been a more profound breakdown of consensus about the difference between science and spin and fact and fiction in the abortion debate. I think that's both furthered and reflected a similar breakdown across our culture. That's made it harder as activists on different sides pursue different sources of information, rely on different sources of expertise for anyone to find common ground, even when in theory we've all embraced equality. If you're interested in more of this argument, I should have put a thing up about my book too. My book deals with some of these arguments too, but I think I'm interested to see too how these equality wars change as states ban access to abortion altogether and potentially pursue criminal actions against women who still seek out abortions at the time of the pandemic.
Thank you, Professor Ziegler, and thank you to all of our panelists for your insightful and important scholarship. We're going to move into the Q&A portion of our panel next. But before I start taking audience questions, I'd like to give our panelists the opportunity to ask each other any questions they might have, or make any comments that they'd like to in light of each other's remarks. So feel free, any of the panelists, to jump in if you have any questions or remarks.
I have a question for Professor Suck, if that's okay. I was really intrigued by your presentation. The quick question is, given that now we're 100 years away from the first introduction of the ERA, if and when it is ratified, what would you expect to see change?
Great. Thanks for that question. So one of the things that I get into in the later parts of the book is the fact that the movement for the ERA in the 1970s actually changed things that had not changed for a long time with regard to the interpretation of the 14th Amendment. So up until 1971, the Supreme Court had never recognized sex discrimination as an equal protection violation. And when they did, in the case of Reed versus Reed in 1971, the lead sponsor of the ERA in the Congress, Martha Griffiths, had actually filed an amicus brief in Reed versus Reed, and she criticized the Idaho Supreme Court's decision in Reed versus Reed on the floor as they were debating the ERA. And then later, when you get a landmark Supreme Court case, Frontiero versus Richardson, in which the Supreme Court strikes down sex discriminatory law. There's a split amongst the justices as to what the appropriate standard of review should be for laws that discriminate on the basis of sex. But there is a judicial opinion that explicitly cites the Equal Rights Amendment and the fact that Congress has passed it as a justification for moving in the direction of greater scrutiny for laws that discriminate against women. And I think these are things that show that it's the 100-year struggle for the ERA, making women as constitution makers that actually changed what the 14th Amendment does. So I think getting the ERA now, which is a question of Congress removing the deadline so that the ERA could actually officially be made part of the Constitution, is a way of legitimizing women's role politically as constitution makers and recognizing the work they've done to change the Constitution that we already have. And so that's it's a different kind of answer from saying the ERA will be this magic bullet tomorrow that makes certain things illegal that are not illegal today. Because as you saw from the wording of the ERA, it talks in it uses words like equality of rights and on account of sex, which have to be interpreted. But I think another thing that's very important, that's part of the later legislative history, which builds upon some of the arguments of the opponents of the ERA from the 20s. Later legislative history in the 70s, a lot of women in Congress like Shirley Chisholm and Patsy Mink talked about how they didn't actually trust judges because judges had been asked to strike down sex discriminatory laws for decades and had not cooperated. So really they saw the ERA as a political anchor for Congress and state legislatures to review their own laws and to start repealing the ones that were inconsistent with women's status as equal citizens. And I think the vision of constitutionalism then is not one that's limited only to judges enforcing and interpreting the ERA, but lawmakers and activists even taking the ERA and remaking legislation so that it actually achieves equality on the ground for women.
Thank you. Do we have any other questions or comments from our panelists?
I don't have a question. I feel like I had the privilege of asking Reba Siegel a question, but I would just like to use my question time to thank this panel. And the audience should know that I pursued these folks because I knew they would give great presentations and would not take no for an answer. And I just really appreciate your all being here virtually. And I just thought that was a splendid group of papers. Thank you.
Yeah, we're very happy to have all of you. So we will move now to some questions. I see that we have some questions from our audience, and I'm going to start with one for you, Professor Ramsey. This comes from a member of the audience who evidently you had in class
Okay.
about 15 years ago, Mario Nicolais. And they say, Professor Ramsey, wonderful to continue learning from you 15 years after I took your class. Could you please talk about some of the domestic violence concerns that have arisen under current stay-at-home conditions? Are there resources you can highlight for victims suffering from such violence right now?
Okay, great. I thought I was in law school 15 years ago. That seems impossible. Yeah, so I think there are concerns for people who are in abusive relationships because this only heightens the stress in those relationships. And I certainly don't mean to suggest that it would be some kind of an excuse for an abuser who uses violence and other means of control during the pandemic just to say that this person is under stress. But I think we are in a situation where individuals are literally physically trapped by the stay-home orders. And I am not aware if exactly what's going on with services, and whether services are as readily available. But I think it is really could be a time of crisis, and there have been various ways that the ability of the pandemic to differentially affect people based on a variety of aspects of their status. Asian Americans are facing discrimination, but I think it is a particularly dangerous time for people who are in an abusive relationship, perhaps a little bit less so maybe if someone is in a relationship that has ended and they have separated from their partner, though we should not be confident that people who would disobey the law and abuse their partners would be obeying stay-at-home orders either. So I think it is a tough time.
Moving on to another question, again, sort of influenced by our current situation. This question is for Professor Ziegler. In the wake of efforts to combat the threat of the coronavirus and widespread medical supply shortages, some states have been moving to dramatically restrict abortion access. How does this unprecedented context impact the abortion debate?
I think that it moves the timeline forward a lot in the Supreme Court's consideration of abortion bans. I think most commentators, myself included, expected that while this court has been in many ways, the majority, at least on this court, has been put in place with the expressed purpose of overturning Roe, that the sort of swing votes on the court would be reluctant to do that quickly. Many believe that John Roberts in particular is concerned about the court's reputation and the kind of concerns about the legitimacy of the court articulated in Casey would have a powerful resonance for him. So what does that mean? That means probably that the court would not overturn Roe, a year after Brett Kavanaugh shows up, because that would make the court appear to be a political entity and not a body that is above the political fray. These laws, while they might not force the court to say anything on the merits, do at least have the possibility of forcing the court to weigh in on what amounts to an abortion ban in the short term. For the court to dodge some of these bans, I think would be difficult because obviously their effects matter tremendously both to patients seeking abortions and to states claiming that they need personal protective equipment, and they matter now, right? So waiting 3 or 4 years to resolve this would do no one any favors. I think these disputes also show something I was talking about in my talk and that I talk about in my book too, which is that so much of the abortion conflict has boiled down to a battle about the facts. So these abortion bans rely almost entirely on arguments about the availability of personal protective equipment and the extent to which banning abortion in a state will make personal protective equipment available. That's contested by those on either side of the question. And so what feels like it should be a kind of rehearsal of the kind of classic clash of absolutes between a right to life and a right to choose has turned into sort of anything but. It's turned into a messy fight about the reality of abortion bans, the reality of abortion care, and the reality of its relationship to personal protective equipment. So even though in every other way, I think the pandemic is already opening a new chapter in American abortion politics, that question very much is part of a longer story that I think helped us to get where we are, which is a sort of dysfunctional, unfortunate place.
Thank you, Professor Ziegler. I have another question here for Professor Suk. Due to the transgenerational nature of the ERA, the language it uses is limited to sex, even though much of the equality discussion today focuses on gender, which would arguably reach a broader population, people, folks along the gender identity spectrum. Can you discuss this dichotomy and how the ERA could be interpreted to protect rights for a broader gender population?
Great. So I think that the ERA that we're getting now is one that was drafted, although the drafting changed. It was drafted in the 20s, the drafting changed a little bit in the 1940s. It didn't really get adopted by Congress until the 1970s. Many of the states that ratified in the 70s, but the completed ratification occurred in the 21st century, just in the last 3 years. And I think this creates an unprecedented set of questions for constitutional interpretation about how to synthesize the meaning of the Equal Rights Amendment. And I would say at the very least, what the framers intended when it was adopted in the 1970s, and there, so much of the focus it was different from the 1920s. The focus was on women's inequality in education and employment, stemming largely from women's traditional role in childbearing and child rearing. And what we could do as a matter of law in transforming those inequalities, right? They were not really focused on this broader conception of gender, although it wasn't absent either. And I think that's why it's actually important that in the 3 states that have ratified, there has actually been a broader discourse accompanying the ratification of the ERA. So if you look at Virginia, which was the last state to ratify, Danica Roem, who's the first transgender legislator in Virginia, stood up and talked about how important it was to have this broader understanding of sex, to include gender, in support of the ERA. And I think that becomes part of how we give meaning to the ERA today. And the Virginia legislature in this session, when they completed ratification, also passed a bill expanding anti-discrimination protections in the state of Virginia to people, banning discrimination on the basis of sex, sexual orientation, gender identity. So I think this transgenerational building allows for this expansion. It's always been part of the changing meaning of the ERA. And I think in some ways that's what makes it so powerful, that there are generations of women and people of all genders who have given meaning to what it needs to be today.
I'd like to move now to a question for Professor Schulten. You touched on throughout your talk, and then also towards the end of your talk, on some of the power imbalances that were not accommodated by the suffrage movement. You talked about Black men being disenfranchised. Is this still a concern that we see in current voting rights issues, this failure to challenge power imbalances, or have we learned from those mistakes of the past?
Well, not to give you too pat an answer, but the past couldn't be more relevant in this situation. To my mind, I think our situation now is part of what I see among my students, which is a renewed interest in Reconstruction. And I know that seems like a deflection, but Reconstruction has such profound importance for us for how we think about voting and policing, incarceration. And it seems to me that the kinds of students and the kinds of questions they're asking me about the Reconstruction era are really a kind of reminder of the connections that are beginning to be made. The new Jim Crow, Michelle Alexander's book, was responsible for some of these direct connections. Ta-Nehisi Coates' work on redlining has brought us back to the history of property and property accumulation and regulation. I would like to say that that we've gone beyond the kinds of debates about voting that were so pervasive in the South in the post-Civil War period and across the country leading up to the 19th Amendment. I think it's undeniable that we are in a far better situation for access to the ballot box, but the arguments remain, right? Who gets to vote? Who needs to vote? Protection of voting, right? And so it seems to me that those could not be more relevant.
Sorry, forgot to unmute myself. In the minute that we have left, I see one more audience question for Professor Suk, asking you to say more about Mary Church Terrell's position on the ERA and the role of women of color more broadly in supporting and opposing the ERA historically. Could you speak a little bit to that, Professor Suk?
Well, Mary Church Terrell is a really interesting figure with regard to the ERA because so first of all, she was part of the National Women's Party and has an interesting history because in 1913, Alice Paul organized a suffrage parade in which Alice Paul really wanted the African American women's groups to march at the back of the parade. And there was a division between Mary Church Terrell and Ida Wells as to whether they should comply with that request. Mary Church Terrell actually organized Delta Sigma Theta, an African American women's sorority at Howard University, and they did actually march at the back of the parade in 1913. And so she was someone who picketed for suffrage and supported the National Women's Party while always also being critical of the racial politics there. And what's very interesting is that as a much older woman, and she was a founding member of the National Association of Colored Women in 1898, right around the time of Plessy versus Ferguson. And she had a career not just as a women's rights activist, but also very active against segregation and challenging the color line. So by 1945 and 1948, she testifies in Congress in favor of the ERA. And it's an interesting moment because throughout the 1920s and 30s, really only the National Women's Party is in favor of the ERA. And you do see a shift in the 1940s. And part of it is because of World War II and because of the UN Charter declaring equal rights for women and men. And Mary Church Terrell also has a very interesting history in relation to international understandings of women's rights because she studied right after college in Germany. She spent a lot of time in Europe and was very engaged with human rights and constitutionalism in Germany, France, even in Italy. And she brought those ideas into the way that she thought about equal rights for women. And then later on, this is getting outside of the time frame that we've focused on in this panel, but later on, of course, women like Pauli Murray, who wrote about Jane Crow and the law, testified in 1970 in favor of the Equal Rights Amendment, and talked explicitly about how the Equal Rights Amendment created an opportunity to be much more ambitious and creative than the Equal Protection Clause. Pauli Murray had developed the Equal Protection Clause to expand the racial justice framings of the Equal Protection Clause to also move into the realm of sex discrimination. But in the 1970s, she also saw great potential for the ERA to go beyond non-discrimination and towards the empowerment of women and overcoming women's powerlessness. And so that was also a very important part of the discourse around the ERA in the 1970s, which I think we would lose by forgetting about the ERA today.
Thank you, Professor Suk. And thank you to everyone for this insightful and enriching discussion. I see that we're at time, so I'm going to give Professor Malveaux an opportunity to jump in here before we take a break.
Okay, great. Thank you so much. Just really appreciate the comments that have been made, the presentations. I did want to follow up. We had a question about domestic violence and resources. What kind of resources might be available to people who are in that are in a situation where they may feel unsafe because of the stay-at-home orders. So we have we pulled a couple of resources that people might want to take a look at. Let me just raise those quickly for you. One is if you go to Violence Free Colorado, their website. I'll see if I can pull that website address up for you. Another recommendation is that you go to this national hotline, which is 800-799-SAFE, 800-799-SAFE, and SAFE is 7233. Okay, so you may want to take a look at that resource. We also have in Boulder, the Boulder Safe House is another resource for people. The Latina Safe House works with immigrants and Spanish speakers. So I'm getting I'm getting some additional data. One more data point for you here. Boulder, the county.org/safety.jail/programs/safehouse. So I just wanted to put that out there so that people do have those resources available to them, particularly during this difficult time. So thank you, everybody. This does wrap up our Q&A portion for panel 1. We're now going to take a 15-minute break, and we will resume our programming at 12:15 Mountain Time with panel 2.